Debt Verdict. DV-007. Title: The Fake Courtroom Debt Collection Scam. Category: Exposed Channel. Verdict. They built a courtroom inside their office. They hung a seal on the wall. They put a man in a black robe behind a raised desk, and they told people they were being tried for their debts. None of it was real, but the fear was, the payments were, and the scam worked for years until the real courts found out. This is the story of one of the most brazen debt collection frauds in American history. To understand how this scam worked, you need to understand something about debt in America. According to the Federal Reserve Bank of New York, total household debt in the United States reached $17.69 trillion by the end of 2023. Credit cards alone accounted for over $1.13 trillion. Behind every one of those dollars is a person who owes money, and a multi-billion-dollar industry that exists to collect it. The debt collection industry in America generates over $20 billion in annual revenue. There are roughly 7,000 collection agencies operating across the country. Most of them follow the law, but some of them have discovered that fear is more profitable than compliance. The Fair Debt Collection Practices Act, the FDCPA, was signed into law in 1977. It exists for one reason: to stop debt collectors from using deception, threats, and harassment to collect money. Under Section 807 of the FDCPA, it is explicitly illegal for a debt collector to use any false, deceptive, or misleading representation in connection with the collection of any debt. That includes falsely representing that they are attorneys, that documents are legal forms, or that any communication is from a court. The penalties for violating the FDCPA can include statutory damages of up to $1,000 per violation for individuals, actual damages, and attorney's fees. In class action cases, penalties can reach up to $500,000 or 1% of a collector's net worth. Those rules exist, but rules only work if someone enforces them. The scheme was disturbingly simple: a debt collection operation, and there have been multiple documented cases of this type of fraud across different states, would set up what looked like a courtroom inside their office space. The room would be decorated with official-looking elements: a wooden bench elevated like a judge's seat, a seal or emblem on the wall, flags, a witness stand, rows of chairs for an audience that would never come. The collectors would wear suits. The person behind the bench would wear a dark robe. Some operations even had a person playing a bailiff, standing by the door with an authoritative look. Then the debtors would be summoned. They would receive letters or phone calls telling them they were required to appear for a legal proceeding regarding their outstanding debt. The language was crafted to sound official. Words like hearing, proceeding, judgment, and court order were scattered throughout the communications. When the debtor arrived, they would be ushered into the fake courtroom. The man in the robe, who was not a judge, had no legal authority, and in some cases had no legal training whatsoever, would preside over a sham proceeding. The debtor would be told they owed a specific amount. They would be told that failure to pay would result in wage garnishment, asset seizure, or even arrest. None of these threats were real. But the people sitting in that chair didn't know that. Many of them were low-income individuals. Many had limited education. Many had never been inside a real courtroom. They had no frame of reference to know the difference between a legitimate legal proceeding and a theatrical performance designed to terrify them into handing over money. And it worked. People paid. They paid amounts they couldn't afford, sometimes by borrowing from family or taking out additional loans. They paid because they believed a judge had ordered them to. They paid because they were afraid of going to jail. The Federal Trade Commission has pursued numerous cases against fraudulent debt collection operations over the years. In 2015, the FTC in the state of New York shut down a massive operation run by a company called William Scott & Associates, which was using fake courtroom-style tactics, threats of arrest, and impersonation of law enforcement to collect debts. The operation had collected millions from consumers using illegal threats and misrepresentations. The FTC obtained a court order banning the principals from the debt collection industry entirely. In another landmark case, the FTC took action against AMG Services and its affiliated companies, which had been engaged in deceptive lending and collection practices. The case went all the way to the Supreme Court in 2021, AMG Capital Management v. FTC, where the court ruled on the FTC's authority to seek monetary relief. The Consumer Financial Protection Bureau has also been active. In 2016, the CFPB took action against Encore Capital Group and its subsidiary Midland Credit Management, one of the largest debt buyers in the United States, for using deceptive tactics, including filing lawsuits to collect debts they couldn't actually prove consumers owed. The settlement required Encore to pay up to $42 million in restitution to consumers. These cases reveal a pattern. The debt collection industry, at its worst, operates on a simple principle. Most people won't fight back. Most people won't hire a lawyer. Most people won't file a complaint. Most people will just pay, even when they don't legally owe the money, because the fear of legal consequences is overwhelming. The fake courtroom is just the most theatrical version of this strategy. But the same underlying tactic, using fear, confusion, and false authority to extract payment, runs through thousands of collection operations across the country. Here's what every person in America needs to know about debt collection. Under the FDCPA, you have specific, legally protected rights. A debt collector must provide written validation of the debt within 5 days of first contacting you. You have 30 days to dispute the debt in writing. If you dispute, the collector must stop all collection activity until they provide verification. No debt collector can threaten you with arrest. In the United States, you cannot be jailed for failing to pay a consumer debt. That has been true since the federal government effectively abolished debtors' prisons in 1833. Any collector who tells you otherwise is breaking the law. No debt collector can impersonate a lawyer, a judge, a law enforcement officer, or a government official. No debt collector can claim that documents are legal forms when they are not. No debt collector can threaten legal action they do not intend to take or cannot legally take. If a debt collector violates the FDCPA, you can file a complaint with the FTC at ftc.gov, with the CFPB at consumerfinance.gov, and with your state attorney general's office. You can also sue the collector in federal or